This is OwlUp, where learning happens in minutes, not hours. For a deeper journey, explore all our courses at owlup.co. Now, let's dive in. Right now in the US, thousands of people are taken to eviction court every single day, often for less than a typical car payment. In one case, a tenant lost their home after their landlord changed the locks, even though the tenant had actually paid their rent on time. Most people sign housing papers the way they click "I agree" on an app, fast, distracted, and hoping for the best. But those few pages quietly decide who can enter your bedroom, how quickly you can be kicked out, and whether surprise charges can drain your bank account. Housing law may sound abstract, yet it shows up in tiny details: the wording of a guest policy, how your state defines notice, whether your city limits late fees, or if your building has to fix heat within 24 hours or 14 days. These rules shift wildly by zip code. In one building, a broken stove triggers a firm repair deadline. In another, you're told to be patient for months. Understanding what's promised on paper and what the law adds even if your lease is silent is the difference between quietly absorbing losses and confidently saying, "Actually, you're not allowed to do that." Behind all those clauses and signatures sit three quiet power centers: who controls the space, possession; what shape it must be in, habitability; and who gets to say yes or no to living there, anti-discrimination. Each state, and often each city, tweaks these in its own way. Some places treat a landlord entering without permission like trespassing. Others are looser. Some give you strong tools if basic services fail. Others leave you improvising. And layered on top is federal law, which can override local customs when bias or exclusion enters the picture. If you strip the legal jargon away, most housing fights boil down to three questions. 1. Who gets to be in this space, and when? 2. What shape does the space have to be in? 3. Who was allowed to say yes or no in the first place? Start with control of the space. Your right to be there usually depends on two things: the exact words in your agreement and the background rules of your state. A written lease might say it ends on a specific date. A month-to-month setup might renew automatically until someone gives proper notice. Proper can mean 7 days in one place, 60 in another, and the clock might start when a letter is mailed, emailed, or taped to your door, depending on local rules. If you leave early or your landlord pushes you out without going through the required steps, each side may owe the other money, but the details usually turn on what your state says about breaking agreements, reletting, and mitigation, how hard each side has to try to reduce the damage. Then there's the physical condition of the home. Even if your agreement is silent about mold, heat, or locks, your state and city probably add non-waivable promises in the background. Sometimes they're tied to building codes, sometimes to judge-made standards like fit and safe. Those hidden promises can unlock remedies far beyond simply asking for a repair: rent reductions, the right to fix something and deduct the cost, or, in extreme cases, leaving without a penalty. In many places, though, you must follow a specific sequence: written notice, time to cure, documented conditions, or you risk being seen as the one breaking the deal. Finally, access to housing itself is shaped by layers of anti-bias rules. Federal protections cover things like race, religion, disability, and family status, but states and cities often add more: source of income, sexual orientation, prior eviction records, or even hairstyle in a few jurisdictions. A landlord who says "no kids," "no vouchers," or "no one with a record" might be perfectly legal in one zip code and clearly illegal a few miles away. The gray area is neutral rules that hit some groups harder: tight occupancy limits, minimum income ratios, or blanket bans on any criminal history, where enforcement often depends on how those rules play out in practice. Think of it like building a layered budget. Your written agreement is the spending plan. State and local rules are mandatory expenses you can't opt out of, and federal protections are the guardrails that stop the whole thing from becoming rigged. Because housing rules are so local, two neighbors in the same city can have wildly different protections based on the paperwork they signed, the type of home they live in, and which funding streams touch the property. Public or subsidized units often come with extra federal strings, grievance procedures, inspection requirements, limits on sudden rent hikes. Private buildings with 5 units might be covered by rules that exempt duplexes where the owner lives on site. Even roommate situations can flip the script. In some places, sharing a home with your landlord turns you into more of a licensee than a traditional tenant, which can speed up how quickly you can be required to leave and reduce which protections apply. One more twist: how you pay can change the legal category. A rent-to-own agreement or contract for deed, for example, may start to look less like renting and more like buying in the eyes of the law, triggering foreclosure-style protections rather than standard move-out rules if things go wrong. Similarly, short-term stays, like month-to-month sublets or extended temporary arrangements, can quietly morph into recognized tenancies after a certain number of days or payments, giving you rights you might not realize you've acquired. The details are messy, but a practical pattern emerges. Text plus timing plus type of housing plus funding source usually determine your real-world leverage. Knowing which category you're in is often the first step to spotting whether a landlord's threat, promise, or policy actually has any legal weight. A concrete example: your lease says no pets, but your therapist prescribes an emotional support animal and you provide proper documentation. In many places, that shifts the rule because disability laws can require reasonable accommodations even when the paperwork seems absolute. Or say your building posts a rule: household income must be 4 times the rent. On its face, that's neutral. But if they accept high-earning applicants with unstable gig income, while rejecting voucher holders whose combined income and subsidy easily clear the bar, enforcement agencies may see a pattern worth investigating. Your leverage can also change midstream. If your city passes a new code requiring self-closing doors after a fire, those doors usually must be installed even if older leases never mention them. And when a landlord advertises no criminal records, but then quietly makes exceptions for relatives or certain applicants, that inconsistency can transform a private policy into evidence someone's being screened out for reasons that can't be justified. More change is coming than most renters realize. Think of policies like weather fronts. Measures like right to counsel, climate-ready building rules, and voucher expansions are slowly moving across the map. Some cities are piloting universal applications, where one form lets you apply to many units, cutting junk fees and bias. Others are testing rent data portals so hidden increases show up like line items on a bank statement, arming you with trends when you negotiate or organize. Knowing all this isn't about winning arguments, it's about spotting pressure points early. A strange clause, a vague policy, a pattern in how neighbors are treated. Each is like a breadcrumb hinting at deeper rules. Your challenge this week? Pick one housing document you've signed and highlight 3 lines you don't fully understand, then look them up. This was OwlUp, your daily step forward. To keep learning with structured courses and more insights, go to owlup.co. Until tomorrow!